Finland, mediation was introduced 18 years ago by the Finnish Bar Association as an alternative for commercial disputes. When we introduced mediation then, everybody understood that this will require a cultural change. It would require some time, but I think nobody really anticipated that it would take that long a time. But as a matter of fact, in the recent years, mediation has really been gaining ground in Finland through a court-annexed mediation system in which judges in our lower courts act as mediators. And when you look at the numbers today, we are over the level of 1,000 mediations per year in Finland. And for a country of this size, that's a significant number. It's somewhere between 10 and 20% of larger civil disputes. Well, one has to say that half of these 1,000 disputes are family matters or child custody cases, but the other half are just ordinary civil and commercial matters. So this means actually that, I would bet that there are many colleagues in this room today that do have experience of mediation in one role or another. I thought that I would maybe ask you to show by raising your hands who that are present here today have experience in mediation in one role or another. Just raise your hand. So that's quite a significant number. And this goes to demonstrate the change that we are going on at the moment. And a very big proportion of members of the Finnish bar have also taken mediation training. Right. If we then go to our panel, I'm very pleased to have this distinguished panel to address this issue with us today. And we really do hope that this will be as interactive as the previous panel. So we look to the audience for comments and questions and also objections. Everything is allowed. But I may then, at my discretion, park a particular question maybe to be discussed at the end if that seems a better way to do it. But please be active. On my left-hand side, we have Heather Allen, who is an independent mediator in London. Heather has been working as a mediator since the early 90s, so you have been one of the, let's say, early persons to enter this new arena in London. You also work very closely with CEDR, which is really the pioneering organization of alternative dispute resolution in Europe, Center for Effective Dispute Resolution. Not employed by CEDR, but as you have a position of trust, and you also head the CEDR faculty. So a warm welcome to you, Heather.
Thank you very much.
Very nice to have you here with us. On my right-hand side, I have Birgit Sambeth Glasner from Geneva, Switzerland. Mm-hmm. Birgit has a background actually as a judge in courts in Geneva. Now is a partner at the law firm Altenburger, which is a law firm based in Zurich, Geneva, and Lugano, if my recollection is correct. But you're based in the Geneva office. And you have also, or actually you are currently chairing the mediation and ADR, or is it ADR commission of the Geneva Bar Association?
Exactly. Mm.
So a warm welcome to you also, Birgit. Very pleased to have you with us. Third, we have Ralf Lindbäck from Wärtsilä Corporation. a senior vice president legal affairs. So you work in-house for Wärtsilä Corporation, which is one of the leading Finnish international corporations active in the area of shipping, maritime, and production of power plants, if I have understood correctly, and of course services. And Wärtsilä is a company present in over 90 countries in the world, with a overwhelming part of the turnover coming from abroad. So very warm welcome, Ralf.
Thank you.
Nice to have you with us. And then last but not least, we have Leena Kujansuu, who is our rapporteur. Leena is with the law firm Lindfors & Co., which is a very well-known litigation boutique here in Helsinki. Very nice to have you with us, Leena. So, with these introductions, I think we just need to embark on our topic. But before doing so, maybe it's useful to talk a bit about what is it that we are talking about in concrete terms. So, when we're talking about mediation, what is it that we're talking about? Birgit, would you like to address that question?
With pleasure. If you don't mind, I'm just going to stand up for 2 slides. If they are coming. Yes. No. Yes, they are. The purpose of the first slide is just to put dispute resolution, or what we call alternative dispute resolution, into perspective. Which means if we go from the least evaluative, least structured, and least formal process to the most evaluative, structured, and formal process, we see that we go from negotiation to, in fact, arbitration, which is the last alternative dispute resolution method, and then, of course, adjudication, which would be the court, which is not considered an ADR, I think, worldwide. And we see that mediation, of course, is at the very top of that very least evaluative and structured process, where parties are almost completely in control, respectively, that no third party is in control. And why I'm showing that is really to say that mediation is a structured process. It's a facilitated negotiation, which means that it's a bit more formal than a negotiation, in which this is the process which is going to help the parties not to fail in their negotiation. Very often we hear that negotiation has started, failed, and there is no need to go to mediation because negotiation has already failed. And what we want to show you in the panel today is, because you're adding a bit of formalism with having a neutral mediator is going to help. And why? And maybe we can go to the second slide. And this is the mediation process. I mean, what are we talking about? We're talking about a negotiation facilitated by a trusted, neutral person. And this is all what it is about. But it's not a negotiation the way we usually do it, we as lawyers at least, which is on the left side of the slide. Very often, we do what we call positional negotiation. And we go from positions to, everybody wants to just stick to his position, and we go from 2 to 8 to 4 to 6, and we somehow find some kind of a bad agreement at 5. And we go from position to solution to agreement. Instead of that, a mediation is a facilitated, interest-based negotiation, where we are going to make the turn and go from positions into exploring interests, into exploring options without putting any value to those options. Then we are going to explore whether those options could be a solution, and then only we go to an agreement. So this is what mediation is all about.
Well, thank you very much for laying that framework. Heather, you have a long experience not only acting as a mediator, but also of training mediators in different countries and continents. Could you tell us a bit in a bit more concrete terms how mediation works and what makes it effective?
I'll try and do that, yes. For those who haven't been to a mediation is an occasion. And I've got a slide which I'm going to put up in a moment, which is, luckily I've called it a definition. I think that every time you get a mediator, there's a slightly different definition, although all the elements that Birgit has talked about are in the definition. And in a way, it's because of those elements that are in the definition that it works. So if we can have the slide, it's a flexible process. So you're not bound, you can read that, so I'm not going to read it out to you. I'm going to explain why the highlighted elements make it work. It's a flexible process, so one of the really important roles of the mediator is to work with the parties, and that usually means working with their lawyers, to devise a process that is going to work for the particular circumstances. What that generally means with a commercial dispute is that you agree upon a day when everyone will come together at a venue with individual rooms available for private discussions, a room available for everyone to sit together when appropriate, or for a mix of people from each team to come together. And from the lawyer's perspective, it is, from the best lawyer's perspective, it's a service on offer to their clients based upon what really matters to their clients. So it's a flexible process, and most mediations are a mixture of sitting round the table together, having private meetings with the mediator, which may then result in a communication between the parties, either face-to-face or through the mediator. It is conducted confidentially. Now, of course, some of these things, I heard in the last session that the parties have an involvement in the process of arbitration, that arbitration has a degree of confidentiality attached to it as well. So you may not yet get the distinction if you haven't already had some experience of the two different processes. So they're very different in one particular respect. So a flexible process conducted confidentially, which gives a degree of safety. Now, there are no cases that I know of where confidentiality has been challenged. There have been one or two cases where judges have agreed that something from a mediation can be included. In one of those, the mediator refused, and after that, she said that she would, but that she would charge her regular hourly rate, both for preparation and for attendance at trial, and the trial never happened, so the thing settled. However, the confidentiality, as with arbitration, does produce a degree of safety for the parties. And the neutral person is there in order to have the kind of conversations with people which you can't have, however good a negotiator you are, you can't have those private conversations with an opponent. And I'll put that in inverted commas because I realize that lawyers talk to each other on the opposite sides of a dispute, they settle disputes, and that's part of the daily work. What we're looking at here is a process which can act where, for whatever reason, those negotiations have either broken down, as you were describing, Birgit, or have never started. So the neutral person actively assists the parties. This is not a situation where just because I turn up as a mediator and I sit there and say, well, we're having a mediation, aren't we? We've agreed on the process, so off you go. I have a really active and strong role both in terms of working with the process, working with the people so as to keep energy going, to retain a degree of rapport and therefore permission to have in private some quite challenging conversations so as to allow people to reassess risk. The lawyers, as most of you in the room will know, will have prepared a risk assessment of some kind before a mediation day. There is a reassessment of risk in the light of what you learn on the day, not just about the legal case, but about what matters to the other party. Because in any negotiation, if I can meet something that you want in a way that suits me, I'm more likely to get a deal that works at the end of the day. So the idea of interests is really important, and I think we're probably going to come back to that. So actively assisting the parties in working towards a negotiated agreement of a dispute or a difference, and I suppose those words are up there in this definition because we believe that a dispute can be averted by having a conversation about a difference before proceedings are issued. And that happens on occasions. On occasions, it's suggested by one party, and for good reason, it's delayed until a little more is known about the case and a little more preparation has been done, and that's fine too, and that's part of designing the process, the timing issues. And the big difference between arbitration and mediation, of course, is that the parties remain in control of the outcome of whether to settle the dispute, and if they agree to settle, the terms are their terms and not the terms of the mediator. And that all looks, I think, quite straightforward and probably doesn't come as a surprise to most people. Just maybe one or two things about what a mediator actually does. I've written a note for myself here to say, actually, they do a lot, exclamation mark. And the reason that they do a lot, despite the fact that they have no power to insist, no power to decide, and no stake in the outcome, is that that's what we're paid for. We're paid to be a conduit both of positive ideas for settlement, the options that you're talking about, and also about what might be couched as the bad news. Because if one party has a deal breaker that they are prepared to disclose and discuss, then it's important that the other party hears that. Now, it depends on what time of day, as you will know from being negotiators elsewhere, that deal breaker is presented, as to whether you take it with a pinch of salt or you talk in some detail about it. If it's 11 o'clock at night, they may as well hear what the deal breaker is. If it's 11 o'clock in the morning, maybe we'll wait and see what happens for the rest of the day. So there are choices to be made in terms of process, there are people to be cared for and taken seriously, and there are decisions to be made about who out of the two teams are actually going to have the better conversations when you bring people together, as well as some detailed work on the challenges of the content and the risks attached both to settlement and to non-settlement. So I think if I'll leave it at that for the moment.
I was wondering if you would like to say something about the structure of the process, sort of what happens in practice.
Yes.
I think not perhaps an exhaustive explanation, but just sort of if one understands mediation as a structured negotiation process, so what are just the basics on the relevant stages?
Perhaps, okay, well, let me put this up now. We use a simple 5-stage model. Again, this is a model. You will be aware of others. There's a 9-stage model and a 10-stage model and so forth. And we use a simple 5-stage model to train mediators and mediation advocates. And so let me just give this from the perspective of the parties attending and the mediator, and we might talk a bit later about a mediation advocate involvement. Preparation is really important, and it's one of the really big differences that I have seen over 23 years, I suppose, now. Actually, I should confess that there was no work in the UK in 1993 when I first became involved. So you were very lucky to get a mediation, and everybody was cheering if anybody got a mediation, quite frankly, in 1993. So most of us kept the day job going for quite a while. But preparation has increasingly become important. And so are the right people at the table? And one of the things that, in a practical way, that I work with the lawyers on is who's going to be there. And it's not just a question of have they got authority to settle the matter, because of course that's important, but it's a question of what kind of conversations are going to take place, who can help the lead negotiator or the lawyer or whoever it is that's participating fully in those discussions, who can back them up with data, with the history, or whatever it happens to be. So, and you may need a legal advisor there, you may in a property dispute need a quantity surveyor. No idea what that is in Finnish, but so I talk with the lawyer about who's going to be present and what kind of documentation they'll need when settlement's reached, whether anybody in the team has got particular needs in terms of timing. There's all kinds of process things that are important in preparation, which can make for a smooth running day. One of the other things I always offer is to speak to the parties in advance if they wish to. And sometimes they'll put me on a conference call when their client comes in with the team into their office, and so that I get a chance to talk to them. And sometimes there's no contact with anybody other than the lead lawyer before the day. In terms of the day itself, I have separate rooms. Let's suppose it's just two parties for simplicity today. I like people to settle in, catch up with their teams, feel ready before they sit round the table together. It makes for a better start to the day rather than rushing people into an event where they feel under pressure. And that opening is really the beginning of a dialogue. Sometimes we have lawyers who say, do we really need that opening? And although I'll have an open conversation about that, my belief is that that opening is very important if it's run well. And certainly I've had opening meetings which have run for 2 hours and have been extremely productive. And I've had others where really it's just putting names to faces, faces to names around the table, and a brief introduction in terms of how the current position is in relation to parties. So again, it's very flexible, and you have to play it by ear as a mediator. You can't plan for a 2-hour opening session. Working from the end, and you'll see some dark arrows here and then some grey arrows. The grey arrows are because it's not quite as simple as you move from preparation into an opening, into some exploration, into some bargaining, and a tidy conclusion. You often move to and fro, particularly in the last 3 phases. You get to a conclusion, people think they've got a deal, and something else bubbles up that needs sorting out. So you move back, possibly to exploration, certainly to bargaining, to discussing about that particular term and how it's going to work. I just want to highlight, concluding is clear. If there's a deal, you write it up, the lawyers write it up, and it gets signed. If there's close to a deal, then the plan is put in place with the 2 teams about next steps. Bargaining is what it is. It's discussing terms and a bit of haggling. And exploration is often missed. And I miss it when I have a problem. I say, what's the problem and what's the answer? Rather than, what's the problem? Is that really the problem? Is there something else that might be discussed today? And in the literature, that's called creating value, looking at what else matters. This goes back to the idea of interests, looking at what else matters to the parties, and therefore what else might be persuasive in a negotiation. And with permission, I'm going to facilitate some exchange on those things. Nobody will tell you all their interests or all that matters to them, but some exchange of what matters to people can make the negotiation between the 2 parties much more productive. So there's a creating of value in the negotiation before you move into bargaining, before you start to share it out, which is the claiming of value. And there's a bit of a haggle in most mediations to finalize the deal.
Thank you very much, Heather. Ralf, why would a company like Wärtsilä be interested in use of mediation?
Well, I would say that we are extremely interested in mediation. And to build a bridge from what you say, from the concept and the practical steps in mediation, let me refresh your mind from where we are coming. And we are, as Petri said, we are in roughly speaking, 90 different jurisdictions. We are in 170 locations. We have extremely knowledgeable and creative colleagues, 18,000, to be precise, and working in energy, shipping, oil and gas, so forth, so forth. That's the reality. Since we started this session, I was looking at the watch, we probably cut something like in between 25 deals of different magnitude. In the life cycle support services, whatever you want to call it, throughout the year, every 45 seconds, a transaction is cut, sealed, and the execution starts. Goes without saying that a certain percentage of these go down the drain and become sour. So that's a bit about the background, a refresher. Coming back to the concept and coming back to mediation as a process. And I said that, yes, we are interested in this one as a method of resolving issues in dispute when we have mass transactions, when we have transactions going over 10 years. Question, what we did do here the past few years back in time, we sat down with management and we decided that we need to come up with what we would call internally a claims and dispute management policy or guidelines, where we try to be very consistent in how we address issues in dispute. Key words in this process was early recognition. And here's the point. It doesn't mean that the lawyer needs to be on top of it day number one. We have established a system where finance and control maps different kinds of situations which may have EBIT impact. Later on, they may not boil into disputes, conflicts. So early recognition and proactive actions is key. Second, we do this in order to restore business continuity and protect our reputation, of course, and ensure profitability and make sure that we are growing. Mediation fits very well into that concept. Anyhow, there's one crucial point here. This is done parallel to a very traditional approach where we map our position in a case or dispute from a legal rights and obligations point of view, traditional positioning, parallel with mapping the interests. This mapping of interests is, of course, also very much responsive to our evolving business. To give you an idea again, concrete example, we cannot afford to have disputes ongoing for several years. Why? As said here earlier today, the page of innovation forces us to fail fast, resolve fast. If we are tied into a major complex litigation, arbitration, dispute for a long period of time, in our business it is devastating from a competition point of view. And of course it would generate also some costs, internal costs and internal time, but of course also external costs. So I think that's in a nutshell how we see mediation. If you want to wrap it up with a few words, our experience has been that we've been able to turn disputes into opportunities and new leads, more business. We have been successful in untapping the hidden potential in a conflict and convert it into much more better and constructive customer relationship and more business. And we are just in the beginning.
Thank you very much. It sounds like quite a compelling case for the use of mediation. Is there any concrete example that you could share with us?
Yeah, there are quite a few. One which I can think of, it's approximately 10 years back in time. And location, the Caribbean islands. Whether that had an impact upon going for mediation, I don't know. But small island state in the Caribbean, I don't want to mention the names, but envision a state which is so dependent upon one single power plant. Tourism goes up, hotels are being built, and there's absolutely a need for more power. Wärtsilä is successful in cutting a transaction, a typical EPC transaction. Project financed in the US, out of the US. Everybody's happy. On-time delivery. Commission startup, everybody's extremely happy. The plant is what you could say an extension of the previous plant, which was built late, way back in time. And we provided something like 3 units there, generator sets, diesel generator sets. That's the background. Customer happy, and we are happy. Weather is fine, nice location. So after 4 years, approximately, there is a huge upcoming clash, claim dropping in from the customer. We bought a horse and we got a camel type of dialogue. This is something completely unacceptable. The plant doesn't respond to the energy demand on our island. We are losing out tourism, we are losing tourisms and lots of losses and claims just dropping in. We are speaking of millions. Of course, we were very concerned as a company. And what we did at that point in time was to create a team which had as a task to do what we call the forensics. We took the case and we started to go through it in all detail, without blame, everything with feelings out, just facts, what exactly has happened. And we were able to get enough of question marks, which we saw that there's something here we don't know in doing that. Based upon the information which we have, the running profiles, having done some service work there, so we knew exactly approximately the dispatch profile of this power plant. We took our file and drew up a strategy that we need to move our customer and the counterparty out from their comfort zone into a gray zone. We need to move the legal dispute to become an issue, a question of technology. And in doing that, we decided to go for mediation. We finally then succeeded to sit down with the customer and agree upon that we'll do a full-blown technical audit. We showed the question marks and what we couldn't understand. We got a third party involved together with the customer. We got the doors open, please come and do an audit. And we did a profound audit. Turns out that the new plant, didn't speak with the old plant good enough, especially when during the past 4 years there had been a growing trend of building new hotels and the energy demand went up. So there were lots of peaks, and the demand, it went ballistic. These peaks in the demand came to the power plant. Our engines, Wärtsilä engines, reacted as they should. They saw the danger, so they shut down. And that was very frustrating for the customer. Whilst the other ones tried to pick up, and supply what there was. Long story short, the outcome was that we were successful in transferring a multi-million-dollar case, which claimants have succeeded to establish themselves in Florida. There were lots of frustration, and the solution was a technical audit, whereby the parties were able to identify the root cause, and we had a solution for that. We suggested to fix it. Needless to say, for ourselves, the price tag was decent, extremely decent. The value for the customer was big, and the wave, sort of the peak, was distributed evenly in between the units, and the plant is running well. Everybody's happy. The final part of the story was the customer considered themselves still to be right. There's something wrong with the plant. And the sort of correspondence went on. We reserved our rights, to whatever. But honestly speaking, it was a face-saving operation. It faded out neatly. And today, we were able to sell to the customer a completely new system, what we call CBM, which is remote monitoring. We keep an eye on it 24/7 to avoid this from happening again. That became a bit more longer than planned, but I hope I gave you a concrete example of how you can convert something into a new business opportunity from facing a multi-million-dollar huge case in Florida to a nice value-added transaction.
Okay, thank you very much for that. I'm wondering if there are any questions at the moment in the audience or comments. Isabella. I think we have the tool
where's
somewhere.
The tool?
Heather asked me if that is a Finnish invention. I was not able to answer. We can revert to that.
It is great.
Well done, Finland.
I was just wondering about your precise method as I understand, chair of the CEDR. Do you mainly rely on caucuses as opposed to the kind of mediation that we rather have in continental Europe, where we tend to have the solution made emerge by the party themselves?
Speaking personally, I really
generally.
That's hard to answer because every mediation will be different and I don't know what all mediators do. What I do know is that what I do and what many of my colleagues would promote is a very flexible process. So if I give you an example, I can think of a mediation which lasted for 8 hours, 7 hours of which we sat around the table together with 3 parties, and I had 20 minutes each with the parties at lunchtime. On other occasions, there are some rare occasions, and I think I can only think of 2 or 3 over 20 years, where the parties have never met. And both of those are extreme examples. I personally really like getting people together, whether it be everybody who's present, so all 6 people in each team, or obviously the bigger the teams, the more difficult it is to run a meeting that's useful for everybody to sit together. But I certainly bring combinations of people from each party together. I think it's counterproductive to have people come along for the day and then be hiding in their rooms. So I like people to sit together and talk. I also know that private occasions where they can talk through concerns with me, try out ideas, where I can maybe nudge them a bit and coach them in perhaps how to present something, those occasions are useful as well. So I know that doesn't answer your question.
Yes, it does.
Okay.
Maybe I'm just going to add something. I think it's very important to have the people at the table, but it's also important to give them some time to, release the pressure, and as you said, to just think it over. I mean, what has been proposed now? Because, I mean, we're going to talk a bit, or you talked before, Heather, about preparation. You know, in the real estate business, we say what is the most important? The most important is location, location, location. And I think today in mediation, lots of mediators would agree, and also, I think also the clients would agree that the most important is preparation, preparation, preparation. And in preparing, you are going to think about alternatives, we're going to think about options, we're going to think about strategies, we're going to think about risk, opportunities. And all of that, at some point in time during the day, will have to undevelop or you know. And sometimes you just need time in your room to just take off the jacket and say, okay, what did we hear now? Oh, you know what? This was not what we were expecting to have. So what do we do with that now? So yes, lots of time around the table. No shuttle negotiation, if this is what we're talking about. Shuttle negotiation is me as a mediator going to you and then to you and then no use. Absolutely no use. But time to reflect is also important, to my point of view.
Please, Ralf.
If I may comment just shortly. I mean, this, I agree with you, first of all. There might be regions where, you know, the procedures is different. For instance, I mean, if you go to US, if I understand, they frequently speak about the East Coast style and West Coast style. And East Coast style means that you meet the parties separately in the beginning, and then, or was it vice versa? that you know, in the understand you have a first meeting together. Whilst in again you go Asia, there might be some more preparation, you know, informal beforehand before you have the mediation. So my comment to your question is that, you know, agree. This is, you know, how I would do it, but there might be certain flavors.
Of course.
Well.
Mm-hmm.
Okay. Any other? Ross.
Petri, if I could just pick up on your opening comments. The trend in the UK over the years has been that mediation was, I would suggest, slow to take off. It was slow to take off because the lawyers didn't like it. They didn't like it because they lost control of the case and the client. Strangely, the growth of mediation, I would suggest, has been driven from the top. It's the judges who, when lawyers go along to court, say, off you go and mediate, and if the mediate fails, come back and tell me, the judge, why it failed. There's a legal debate about whether they can impose a mediation, but there are sanctions which the lawyers listen to in the UK if the mediation fails. Linking that to what you said it's been relatively slow here as well, Petri, but now the numbers are going up. However, these are mediations with the judge as the mediator. My question would be, do you see the trend in Finland being that the courts will start imposing mediation on the parties, and if so, with what sanction?
Excuse me, do the courts?
The court, I have a claim against you. It's a commercial action. The judge, when it comes to an interim stage, will say, off you go and mediate, and you come back to me if the mediation fails. So it's a mediation imposed in a high court action by the judge, but he's not the mediator. But what you were suggesting, if I understood correctly,
yes,
was that your judges are the mediators.
So the difference in very brief terms is that in Finland, instead of sending the case to an out-of-court mediation, the judge says, okay, how about me sending this case to my colleague, Birgit, who is a judge who has been trained in mediation? If the case settles, that's it. If you don't manage to settle, then you come back to me and I continue. sort of the idea is that you don't mix the two roles. And I think that is crucial, because otherwise it creates a number of problems. It sort of pollutes the legal process, and it pollutes the mediation, because parties will not be very open about their real concerns or interests if they know that they are talking to a person who will ultimately decide the case if the case doesn't settle. But sort of what we anticipate is that the increase of court mediations will likely increase also mediations out of court. Because, I mean, there are certain advantages attached to that. I don't know if, Heather, you would like to comment from a UK perspective to a UK...
I just had one thought as you were speaking. I think you said that the judge would impose mediation. You and I both know that's technically not true. What they do to is encourage it. And yet people do sometimes feel obliged to at least look as though they've tried it. So there's no mandatory mediation in the UK at the moment, but there's an ongoing debate.
That's obviously right.
Mm.
The point I'm coming at was the reason it worked is because there are sanctions.
Yes. Yes. Just in case people didn't hear that, shall I just repeat that?
Yes.
So the reason it works, it's been suggested here, is that if a judge suggests that they might try mediation and one of them refuses, then there might be cost sanctions attached when it comes back to court, and that has encouraged people to try mediation more often, and even the skeptics have sometimes found that actually it's a process worth participating in and that gives them what they need.
And that is something we don't have in Finland. We don't have specific cost sanctions, so it's different ballgame.
From a Swiss point of view, we don't have that either. We don't have the sanctions, but we have now more and more. I mean, we have. It's not court-annexed mediation, but mediation is provided for in the civil code, civil procedural code, as an alternative to conciliation. And also, the judge is allowed to propose to the parties, not to send them, but to propose to the parties to go to mediation. And we are having, as a president of this CEDR commission of the Geneva Bar, we are very much talking with the judges today in order to understand what's going on, why, even though the cases are increasing, why it's not increasing so much. And they are telling us, listen guys, you are talking to the wrong people. The people who don't want us to send the cases to mediation are the attorneys. And so we took the things from the other side and said, finally, why don't the attorneys want to go to mediation? It might be a matter about fees, but I don't think that it is today, because we are having corporations. I mean, working in Switzerland, we have Nestle, DuPont, and so on. They're all coming now to the lawyers and say not, how many cases did you win last year? But they're asking, how many cases did you settle last year in beauty contests? So what we realize is that the old lawyers, and I'm putting myself in this team, are not accustomed to mediation. So they don't know how to handle it. So the first thing to do, and I think we're going to talk about that in a couple of minutes, is to educate the lawyers in order for them not to lose faith, and in order for them to be part of the process and so on. So it's not only about sanctions. It's also about sanctions, though, from the bar. And I think at some point in time, and we have seen a couple of cases in the US right now, where companies are coming to their lawyers and say, listen, why didn't we mediate? And you have a professional obligation to help me finding a settlement. So why didn't you propose mediation? But this is something else. This is America.
I was thinking that this is a perfect link to discuss a bit like mediation advocacy. Before doing that, Ralf, did you have a comment?
Very short one. I would like to remind everybody of the flexibility mediation brings about. Coming to what Ian said here, settlement, yes, but partial settlement is also available in mediation, that you may choose one part of the dispute and go for mediation, that part. And to be more concrete, as we speak, we are seriously considering this type of a solution in Brazil, where we have an issue of multiple parties, multiple different contracts, long-term contracts. Obviously, that brings about several different jurisdictions and venues. And we intend to test whether we could sit down and resolve through mediation. Where should we have the fight?
Of course.
Or also to that extent, which part of this dispute could we just park or enter into a non-escalation agreement to make sure that it doesn't blow out of proportion? So the point I'm trying to make here is that mediation is extremely flexible, it's party controlled, and it gives you all the opportunities to resolve it together with a mediator, so that you can come at least one step ahead. So that was my point.
Yes, well, Heather, you as a mediator, how do you see the role of counsel in mediation? I mean, if the focus is more on interests than rights and obligations, one could think that lawyers are not needed at all. So what's your view on this?
Well, I wouldn't dare say that sitting here, and indeed, I want to say that as a mediator, for me, it's very important that the parties come with good advice, and that, of course, is primarily legal advice because most of the cases are in a legal context. It may be financial advice and other kinds of advice. If they don't have proper advice, and that might partly be preparation, but it's on the day they need the advisors present too, for the most part. Then actually these are big decisions that people are making, and it's inappropriate for them to make those just because they're working in a process which actually speeds up the process of resolution. It's even more important that they have their advisors present. And personally, I dislike doing mediations particularly where one party has decided, probably because they've had a dispute with their lawyer, frankly, not to bring a lawyer, and the other party is bringing a lawyer. That's the worst scenario. A scenario where neither party brings a lawyer, and I can think of an oil industry dispute in the very early days of my mediation career, where all of them knew each other, so huge industry, small world, and they all decided that they were used to negotiating and that none of them would bring their lawyers. And actually it couldn't be settled on the day because it was quite clear that in terms of actually documenting something so that it covered everything that each of the parties needed to cover, it just shouldn't be done, never mind couldn't be done, it shouldn't be done without proper legal advice. And so we then had an agreement about, in fact, in preparation, I was talking to them about how you're going to do it if you haven't got lawyers present, and they agreed that there'd be a cooling off period. So it can be done, it's flexible, as you say. I think lawyers have a very important role on the day, and I would like to say that although it's true that in England now I quite often speak to a lawyer who's never been to a mediation, they now know what it is, they've read about it, they've talked to colleagues about it, but they still, perhaps some have not been to a mediation. And I have a really important role as a mediator in bringing them into the process. And you talked about saving face. They want to do a good job for their client, of course, and that therefore I have a role in helping them to see what their role is and to do that well. The best lawyers are the ones who make a shift for the purposes of mediation into a broader business advisory role. They are still there with the backbone of their legal case and what will happen tomorrow if it doesn't settle. And that, of course, is the context in which they are advising about risk. But they are advising about a lot more than that on the day, and that's what sophisticated parties need from their lawyers on these occasions.
Yeah, I think I saw Henrik Fiber's hand up right there. So do we have the device?
Thank Thank you very much. Henrik Weber from Roschier in Stockholm. I think, even though it might have not been said expressively, but it was at least suggested that part of the reason why mediation is not more popular here in the Nordics could actually be the fault of the lawyers and the attorneys involved, the client's attorneys. If that's the case, would there be ways to change that? I listened to a very interesting presentation at the ICC about a month and a half ago by the former director of the ICC Mediation Institute, and she said that maybe there should be alternative fee arrangements, financial incentives for the council in order to promote their willingness to push for mediation, which really is what the clients want. What would you say about that?
Who would like to address first, Ralf? You're the right person to talk about lawyers' fees.
This is my favorite. Yeah, let me try at least. Yeah, there are. And there are lots you can do. In my mind, there's untapped hidden potential in traditional lawyering, which should be explored. To put it in other words, expand the pie of services available to customers and principals. What do I mean? And I may be wrong, but I have a vision and understanding. There is huge knowledge with you, everybody here, when it comes to creating blueprints in mergers and acquisitions and analyzing these type of documents and coming up with, based upon your big data and your knowledge from past 25, 30, 40 years, this is how this acquisition probably will fly the next 5 years. And you are happy to sit down with customers to discuss that type of a scenario. Am I right? I hope so. Now, I take that scenario and I come to you with a complex legal case. And I tell you, you do the same exercise with my complex legal case. Do a model, do 3, do 5. And we'll sit down with management and analyze how your model fits our model, which we are doing today internally, or the potential outcome of this complex dispute. And let's see if we have a common ground there. That's just one to give you an indication. To be very practical, if I would like to engage you in a complex dispute to protect my interest, and please correct me if I'm wrong, you will probably at one point in time come with me, this is our engagement letter, sign it. I will scrutinize it and fine. But most likely this engagement letter is fairly undetailed about your role if we shift gears into mediation. There's absolutely nothing there. There might be something about settling the case, but I'm truly interested in how do you intend to take a new role when we enter mediation, or for that matter, other alternative dispute resolutions. And I would be interested to see more sort of meat and beef there. And that's as a hint to everybody else, if you want to be offering legal service in the future, please consider also if you change gears and you want to step into the shoes of mediation advocacy. That was the word.
Thank you very much. Any further thoughts from Birgit?
Yes. I mean, talking about the financial sides, because this is a bit what we're talking about. On the lawyer's side, we have been thinking very much about those issues. And I don't know whether a pactum de palmario is something you can do in Finland.
On special grounds?
On special grounds. This is certainly something, at least in Switzerland, you could be doing. where in fact you are also participating in the progress of the negotiation, on the results and so on, but something which have to be discussed, of course, with the customer first. And this is certainly a role of the lawyers also, is to change the way to discuss letters of engagement. Because we're not only going to say, okay, you need me to, represent you, but what exactly do you need? What are your interests? Where do you want to be in 7 years from now, talking about Swiss perspective? You want to be at the federal court, or you want to be doing your business in whatever? So this is all going to be part of the discussion about the engagement letter. What do you need? What do you expect from me? What kind of roles do you want me to play? Do you want me to play only the role of an advocate, or you want me to play the role of a coach, of a reality checker, of someone who is going to accompany you in a mediation where we are going to think about risks, not only legal risks, but, So the whole thing is changing. I mean, I think the perception, and one of the first roles of our profession, to my point of view, is to address that, because otherwise there will be other people taking this share of the market. And there is a huge market out there. And if we don't take it, there will be other people taking it. And I tell you, in Switzerland, I mean, at least in Geneva, which I know very well, right now, there are plenty of people, so-called dispute facilitators, who have no knowledge about mediation, who are trying to get into that field and going to companies and say, I'm going to help you resolve your dispute. So lawyers, just wake up. This is my message.
There's a hand up there, but before, would you like to say something, Ralf? Or we have a couple of hands up there in the audience in the back. I don't see that.
Let's have the audience.
There's one here as well.
There's one over here.
There are now several hands up here, but right there, the gentleman who's standing up.
Indeed, it's a very cool tool. My name is Ruven Bodenheimer from Cologne, Germany. I have a question with regard to the qualification and the selection of the mediator. In my practice, I experienced that when parties indeed are inclined to conduct a mediation process, they quite often come up with certain requirements and perceptions of what a mediator should be like and what his background should be. Like it should be it's an electrical engineer in a co-mediation together with a lawyer, and he must have experience in power plant construction, but he may never ever, or she may never ever have worked before with one of the competitors, and you only have a few competitors who do build such sites. And I personally think my practical experience tells me this is not relevant. This is not what matters when choosing the appropriate mediator, even in a co-mediation. So my question is, if you disagree, that's my first question, why is that? Or if you agree, how do you think one can overcome these concerns and requirements formulated by parties mostly? And my second question is, with regard to the selection, if you were to choose a mediator, what would be your 3 to 5 questions you always would like to ask a mediator in a beauty contest, besides how many mediations have you conducted or something like that? Thank you.
Okay, thank you very much. Heather, would you like to start?
Let me say first of all that as a mediator, I agree with you. I know that, and I can probably mediate pretty well any case. And I say probably and pretty well because, just because. And if I felt when I got offered a job that I couldn't do a good job, then I would say so, as no doubt would you. So if they come to me for something which ethically I can't do, then obviously I will say no. But broadly, I agree that a mediator is a mediator and can assist parties to work towards a negotiated agreement. What questions would I ask? I would want to ask about process, because a mediator that has a fixed process and always does this for half an hour and that for half an hour and then does that and then does that and never writes up on the day because they think people need time to think about it. Somebody who does a rigid process is not offering the best service to people, because every situation is different, the people involved are different, the business pressures are different. So I would want to talk, I would ask a question about, tell me about how you approach process. And if they gave me a rigid answer, I wouldn't have them as a mediator. I might ask about a mediation that didn't settle on the day and how they handled that, because I believe that the service goes beyond the individual, the day that you've set aside for the mediation. And there are sometimes good reasons why the matter can't be finalised on the day, and I think the mediator has a role in continuing that, and I'd want to hear that from them. And I can't think of a third at the moment, but maybe one of my colleagues can. If I think of one, I promise I'll tell you.
So maybe one of the thoughts that I would have if somebody said that we need somebody who's familiar with power plant construction and Norwegian law and speaks Lithuanian. I'm wondering if this sort of a person, if it exists, but maybe the bigger concern is what are really the expectations of the parties? Is it a mediation, or is it somebody to tell who's right and who's wrong? Yeah. Any additional thoughts?
Yeah, I mean, we're talking about perceptions here. If you need to trust me, I mean, in order to be able to mediate with I'm taking now the position of a mediator, you need to trust me. And if the trust goes through me being the specialist of turbines and speaking Lithuanian, then we might want to go that path and think about why do you need that? And we might want to clarify the process that I am not going to make any evaluation of the issue and so on and so forth. But this is something you have to address. And certainly this is, to answer the question, one of the questions is, what do you expect from me? What is your perception of the process? Let's talk about that in order to meet your expectations, because otherwise the process might be at some point in time failing. Mm-hmm. So we have to address that. Now, I mediated one of those cases, turbines in Brazil with 5 companies, German, Brazil. And this was the start. It was an ICC mediation, and this was the start. And finally, I think the role of the institution is also very important, to help the people understand what kind of expectations they have to have with respect to this kind of settlement proceedings or a dispute resolution proceeding. So the institution was, to my point of view, very helpful also for the people, for the clients to understand what they need and whether or not they need someone who is going to be evaluative and understands about the issue, or someone who is a specialist of facilitation of communication.
Yes. I was wondering if our rapporteur has any concerns or questions at this point.
No concerns. I think that we have actually found the answers the second panel was raising, because I find this interplay of the two panels rather interesting. The second panel was asking for more control of the parties, and now we are here providing for the answer, which is mediation, as also Johan stated in the second panel. So maybe in a few years we will be all sitting in Helsinki International Mediation Day. But actually, going a bit back to the selection of the mediator, now that also we are going to have the new mediation rules coming from the FIA, and as Petri, I think, said that we have high hopes for these new rules, I see myself as an attorney in a few years, or maybe even quicker, in a situation that I need to shortlist potential mediators. Okay, coming from Finland, I can already say that the potential shortlist for arbitrators is already rather limited, let alone then say that the shortlist for potential mediators is even more limited. What kind of personality traits should I be looking when thinking of shortlisting mediators?
If I may comment, and also answer your question. I would say that there are personality traits which we find important from our point of view in our council. Listening skills, number one. It is helpful, and here I come to what Birgit said, sometimes it's helpful to have a mediator who has certain knowledge of shipping or the marine industry. If we have a dispute related to that field, we would hardly go for somebody who is, from farming or something. But it doesn't need to be very specific. It could be a lawyer, it could be somebody who has technology background and so on. But the overall playground we find important. So listening skills, some knowledge about the market and the business is helpful, I would say. Communication skills, of course, is good. And finally, sometimes, the ability to, the glimpse in the eye, the right spot, let the pressure go out a bit. Not, how should I say, it's serious, but in some instances, when a mediator recognizes we are just human,
Yes.
with saying to the mediator himself, herself, I'm just human, and giving it a smile in saying that has tremendous effect on the atmosphere in the mediation. Full respect for the parties, but it's such sort of situational awareness is nice to have. It's not a must, but it helps.
Yes. I was wondering were the hands up here? Sorry. Yes.
I represent the specialized arbitration court for transport in Romania. So, first of all, I would like to thank all the esteemed speakers for their patience and tolerance towards our questions. And my question is, we are all well aware of the fact that the idea of arbitration online is progressing and becomes quite popular nowadays. So my question is, what is your attitude towards a possibility of mediation online or mediation? And do you have any precedents in your practice of mediation online? And do you think it may be advantages in terms of quite tight business schedules of our clients, or it is disadvantages because the main sense of mediation is a personal contact with a customer? Thank you very much.
Yeah.
I'm happy to.
Well, why don't you start?
Okay. Yes, we do, because Switzerland, Geneva is the place where the WIPO, the WIPO has its seat, and you have all the domain name dispute resolution, which is performed online. What I would say is, it very much depends on the personality of the mediator. Don't do it if you do not manage the technicalities. But if you do, and I have seen, I do not manage them, and I need to have the people. These are my skills. But I have seen other people with GoToMeeting, with all those tools, being extremely successful. So I think all of that will depend on your needs and the way you function. And this is exactly what we're trying to do, is to say, finally, we want to have a tailor-made process where we're not only going to discuss, but where we go to a result, because this is also one of the skills of the mediator, to be able to bring the parties somewhere, but with the tools the parties are the most comfortable with. And it's very, I mean, it's very helpful. I mean, speaking now to GoToMeeting, these kind of tools can be extremely helpful. And you can have plenty of people at the same table, I mean, more or less table, where you can show documents and so on. I have seen it. It can be extremely successful. So why not?
I think this goes back to the first session this morning, actually.
Yeah.
Technology is moving apace. Yeah. And as we heard, there are lots of risks attached to that, but leaving those to one side, there are some benefits, and we can use technology for the benefit of parties in dispute. I am perhaps I am reluctant to move too far in that direction, because if we think about Ralf's examples, I don't think that you're going to create the same relationships and develop the same relationships between people through technology at the moment. It's still a bit clunky, however good GoToMeeting is. You might use it for parts of the preparation. In fact, I do use it for parts of the preparation. A conference call. I prefer not Skype, because then I have to, look okay. But we shouldn't ignore technology as part of the process. What I don't want to do is to give up the personal relationships because technology is cheaper or quicker or something.
Yeah. No, I tend to agree. I think that as we speak, we are looking into, to give you an example, warranty claims, for instance, that if we have a customer who wants to present a warranty claim, could that be easily handled through mediation or something like that if there's a dispute? But bottom line is, as Heather says, face to face, sit down. Let's think forward and see what we can do.
Okay, Erik Schäfer.
Regarding online mediation, of course, with end customers, this is probably the only way, if you have cross-border transactions, to provide them some sort of easy problem solving. I wouldn't really call that mediation, but we should be aware, if we use technology, normally we have somehow, as human beings, adapt our ways to do things to the technology. Look at the computer. When you work on your desk, you have all these papers spread out. You cannot do this on a computer, and you just limit your possibilities of expression, of communication, if you base that on technology that is made by engineers who have an engineering look. And somehow we have not yet gotten to a point where these constraints are no longer felt. So I personally feel that we are technology-wise not yet ready to do mediation if not everybody is present in one room at a certain moment in time. At least we miss a lot out if we don't do it. But I have another comment. I hear this story that lawyers are an obstruction to the development of mediation so often. And it's something where I'm not so sure whether this is really the correct analysis of the facts. I believe that if we look where mediation has taken off, it's very often out of dissatisfaction with the court system. People don't go to mediation because they love mediation, because they know a lot of mediation. They, in fact, know very little about mediation because they do it once in their life. It has taken off, for example, in family matters with children, where the courts just do not provide an answer. The law cannot provide a correct answer for each case, for example. And in other cases where simply access to courts is too expensive, or where the courts forces, like in the US, people to go to mediation because for some reason they don't want to have these cases. I don't know. So I rather believe, if it's not taking off here in Scandinavia, if this is true, and the same could be said in Germany for commercial mediation, it's because we have some other ways to deal with this in backrooms, negotiation. We have a very strong negotiation culture where perhaps we do not feel this need for a third party, even if a third party would in many cases add value. But I believe we have this tradition, and we are not so unhappy with our courts. And another factor could be that clients sorry to say this, do not efficiently use the lawyers. They do not give the right mandate. If, I mean, somebody walks into my door and said, Eric, you have to litigate against this party. You have to defend me, or you have to file a claim. Of course, I do what the client tells me to do, because the client normally doesn't like me to say, do you really want to litigate? Wouldn't you like to do something else? Shouldn't we talk? You're crazy. This guy has done something horrible to me. Please file the claim, or I go elsewhere. So the point is, the client has to come, describe the problem, and say, Mr. Schäfer, I have this situation. What do you think would be the best way to get me out of this trouble in an efficient way? And then you get the advice. But you have to ask for this advice and not go and ask for something else and then hope that I send you elsewhere. This is, I think, a very important factor. The clients have to give the correct mandate if you want to get this holistic type of counseling. Thank you.
Maybe before giving the word to Isabella and then
I would just like to emphasize at that stage the role of the IMI, the International Mediation Institute, who's, the main institution in CEDR at the board of the IMI. And the role of the IMI first to enhance, to settle high standards of quality for mediators, and second, and very, very important role, is to make all the users, to give the users an access to all these mediators, not only to their CVs, but also to their way of mediating. And so all the mediators are, let's say, IMI certified, meaning that I've over than 20 mediation in their experience. And it's not only for, I insist on the fact that it's not only for international mediation. I mean, you may find a domestic mediator which has the level of an international mediator. You know, it's a difference between level and skills, whatever, in languages or not. So I think it's very important. I would like to take this opportunity to inform the audience about the GPC, this global PAN conference that the EMI is organizing. And the first started in Singapore in last March.
Yes.
The last one will be in London at the end of 2017. Mm-hmm. We will have one in Paris in April 2017 as well. And these conferences are not only focused, well, their primary role or goal, let's say, is to gather all the information from all the community, not only in mediation, but all the community of, let's say, interested in solving disputes, to get really their input about what their expectation and views about what should be the dispute resolution in the next coming years. And my view is in 2050. So you see that we are rather ambitious. So I just wanted to inform the audience about that, because we can turn these events into very, very interesting events, where not only on mediation or arbitration or this or that, but in settling, resolving disputes as a whole. And that's, I think, the point of view of users. They are not interested in one way or the other. They're interested in all of them and the combination of them. And my last question, if I may, would be about all the, what is the panel view about interest of co-mediation, especially in multicultural disputes. Thank you.
Thank you very much. It may be that we need to wrap up. We just have time for a couple of quick thoughts, because we are running out of time.
Sure.
But then we will have the opportunity to continue the discussion during the evening. But, I mean, just very quick, brief remarks.
Brief remarks about mediation? Or remarks?
I mean, if you wanted to comment on something that Eric said or last.
Yes, I think court system is fine. It certainly is working well, and we certainly have recourse to court systems. The issue here is that the outcome of the court proceedings has an embedded, you're right, you're wrong. And saying that, then next is you are at fault. You're to blame. Mm. And next thing is that there are, nevertheless, in most jurisdictions, fairly tight pipelines of what type of action you can bring about in a court. which from time to time doesn't fit well with long-term agreements and customer relationships, even though you have a dispute. So my point, my comment, very simplified one, excuse me for that, is that the design is well, but it doesn't fit the business needs every now and then. Therefore, we need solutions. One of the solutions is mediation. There are other ones as well, in order to preserve the business relationships.
I would almost be tempted to end there with these important words, but if you want to have a final say.
I don't want to have a final say, but I just want to address an issue which has been the start of today. And just comment on what Isabel said. IMI, International Mediation Institute, is proposing mediators, and everybody who is a trained mediator can be recognized by IMI. And what is interesting is the public, the clients, can go to the IMI sites, find the mediators, and see the feedbacks. And this is why I would like to address that, because women and men, men and women, young or old, are welcome to be mediators, and they are not going to be qualified whether they are young or old, but because of the feedbacks they are going to get on the way they are helping people to resolve disputes. So this is also another way to qualify. We were talking about the arbitration today. Another way to see also our profession evolving. There is space for everybody. We just have to be damn good. This is it.
Thank you very much. I'm sorry for those who didn't get an opportunity to ask the further questions, but I would like to ask the audience to join me in thanking our panel and our rapporteur. And thank you for your active participation. I think we still have a couple of steps before the cocktails, so I don't know how this continues now. Thank you.
Thank you.
Thank you.
Good evening. I think it's time to say evening. It is a real privilege to be the last speaker at this conference before, of course, Mika's concluding remarks. And it is a great pleasure to be in Helsinki again for the second time. For the second time in the month of May, I must say, and I don't think I have to add anything. The title of my remarks in the program was left deliberately vague. It would be, in fact, unconscionable of me to speak about the present and future of international arbitration in 20 minutes and at the end of such a long and intense day with drinks looming outside. And I know this is what you're keeping you here, certainly not my remarks. In fact, I will try to discuss in the time I have the present and future of international arbitration from one particular angle, which is the place of arbitration. Trying to observe the evolution of trends in this respect over the last, I would say, 20, 30 years, and possibly try to identify where we are going. So I'll try to do so from an ICC perspective, of course, an ICC court perspective, and try to identify trends and also the factors of the competition among arbitration centers. Try to distinguish also between old and new venues for international arbitration, and also competition among the established centers for international arbitration. As a threshold observation, I think it is fair to say that users of international arbitration today enjoy a much broader choice of reliable places of arbitration to choose from when they have to select a venue of arbitration. And so do arbitration institutions, of course, when they have to select a venue in the absence of parties' agreement. So let's start with a very brief statistical overview. I think an analysis of the evolution of the place of arbitration in ICC cases shows a very clear trend towards diversification. Diversification is certainly one of the key words. So just to give you an idea, in 2015, last year, 97 different cities in 56 different jurisdictions were chosen either by the parties or by the ICC court as places of ICC arbitration. In 2014 and 2013, the number was even higher. So over the last 10 years, these figures have increased steadily and very significantly. Looking back over the past 20 years, it is clear that these figures have more than doubled. In 1992, for example, ICC arbitrations were seated in no more than 25 different countries. This is, I think, a direct consequence of the increasingly international nature of ICC arbitration, which reflects similar trends also in other fields, for example, other parameters, for example, the nationality of arbitrators involved in ICC cases, and more importantly, and I'll come to this in a minute, the nationality of the parties involved in cases. So talking about arbitrators, for example, last year, 2015, ICC cases, new ICC cases registered involved arbitrators from 77 different countries. Back 10 years, in 2005, the nationality represented were only 68. To give you a more concrete example, the percentage of Asian arbitrators increased from approximately 7% in 2014 to more than 12% in 2013, which was the record year. And in the same period, the number of arbitrators from Northern or Western Europe decreased from 62% to only 54%, and down to 53% in 2015. Although these trends are, I think, generalized and particularly evident in the last 10 years, I think the rate, the pace of diversification is not seen equally across the board. So, for example, the choice of Northern and Western European jurisdictions as preferred seats of arbitration is not declining as rapidly as the origin of the parties from the same region. So in 2014, almost 48, so almost half of the parties involved in ICC cases were originated from Western and Northern Europe. The number dropped to 31% in only 10 years. In the same period, Northern and Western seats dropped only from 69% to 64%. These figures clearly show that the decreasing predominance of Northern and Western Europe overall in ICC arbitration, but also that the diversification of the origin of the parties and arbitrators involved in ICC cases and of the choice of the applicable law as well, is not directly proportionate to the diversification of the place of arbitration. I think more generally, the list of the top 20 countries and cities chosen for ICC arbitrations is very different from is not very different from what it used to be only 20 years ago, whereas the top 20 nationalities in terms of parties has changed significantly. Talking about places of arbitration, since 1998, the first 5 places of arbitration have not changed: Paris, London, Geneva, and Zurich. Although the order might have changed over time, with Singapore and New York competing for the 5th place. And I would say since 2007, almost 10 years, even the order of the top 5 seats has remained almost unchanged, with Paris first, followed by London, Geneva, Zurich, and Singapore, with the only exception of New York, which became the 3rd place of arbitration before London and Singapore in 2015. So this necessarily very succinct statistical analysis seems to show, and I think this is another key term, a certain conservatism when it comes to the choice of the place of arbitration. So only a very limited number of jurisdictions and cities have managed to impose themselves as important centers of international arbitrations in the past 20 years. These generally correspond to what are considered financial and legal hotspots, development of which seems to have attracted arbitration much more than what I would call homecoming trend, which is the choice of the place of arbitration on the basis of the party's nationality, the parties involved in the case. So, for example, in Asia, a financial and legal hotspot Singapore has succeeded in attracting numerous international arbitration cases. Again, statistical data, only 12 ICC arbitrations were seated in Singapore in 2006, only 10 years ago, and this number rose to 38 last year, so a huge increase. The same is not true for other places in Asia, despite the huge growth of Asia, so places like Kuala Lumpur or Bangkok or New Delhi, despite the huge increase of parties from these countries, haven't seen a similar increase. In recent years, I think we all heard and read that numerous cities were prophesied a future or an imminent important development in terms of becoming important venues for international arbitration. We heard this about Dublin, Mauritius, where, by the way, the ICA conference was held only a few weeks ago, Istanbul, Beirut, and even Honolulu. And none of them, of course, we can now say, has found a place among the most popular global arbitration hubs. So only, as I said, a very few cities managed to enter this number. I think two observations are, of course, in order when we consider this data. The first one is that it takes some time before parties start referring to a place of arbitration and the time when this results in a dispute. According to ICC data, there is generally an interval between 2 and 5 years between the time of the contract on average and the time when this results in a dispute. And the second is that although the list of the most popular places of arbitration has, as I said, hardly changed between 1998 and 2015, it is quite noteworthy that in 1982, which is only 15 years before Singapore entered the list of the top 5 places of ICC arbitration, not a single ICC arbitration was based, I'm not saying in Singapore, but in Southeast Asia at all. Therefore, this means that the possible pace at which a city may gain importance as a possible place of arbitration and the emergence of new hubs in the next few years should not be excluded, because this happens, of course, very, very rapidly. Now, let's come to the criteria for the choice of the place of arbitration. Professor Hans Smith once semi-jokingly remarked that the sole important characteristic of a good arbitral seat is the quality of hotels and the local gastronomy. Considering what I will say in a few minutes about my own country, Italy, I have some doubts, especially as far as gastronomy is concerned. According to in-house lawyers interviewed for the purpose of the 2010 Queen Mary survey, the place of arbitration is the second most important choice after the choice of the law governing the contract, the second most important choice to be made in drafting a dispute resolution clause. And the most significant factors in doing so were identified in, first, the legal infrastructure. 62% of the interviewees responded the legal infrastructure is the most important consideration, and this includes, of course, the quality of the national arbitration law, but also more generally considerations about neutrality and impartiality. Now, neutrality is a term that in international arbitration is more frequently referred to the arbitrator than to the place of arbitration, but I think it plays an important role also with respect to the place of arbitration, and it has a double role with respect to the place of arbitration. It has a first meaning, which is, of course, I would say geographical, and it depends also on the origin of the parties. A certain place of arbitration can be considered as being neutral with respect to whom the parties involved in the case are. So in a way, it is impossible in this respect to say what is a neutral place of arbitration in the abstract. But the second meaning of neutrality with respect to the place of arbitration is neither geographical nor contingent about the nationality of the parties, but it has to do with the overall arbitration friendliness of a certain jurisdiction, as reflected in particular in the track record in enforcing arbitration agreements and arbitral awards, and whether, of course, the jurisdiction is a signatory to the main arbitration conventions, including the New York Convention. In fact, as also noted in the 2010 Queen Mary survey, whether the country is a signatory to the New York Convention is for arbitration users, of course, a priority. But given the generalized wide acceptance of the New York Convention, it is fair to say that it is now generally expected, and places of arbitration which are not signatory to the jurisdictions which are not signatory to the New York Convention are not even considered as suitable places of arbitration. Second, the law governing the substance of the dispute. Almost half of the interviewees responded this is a factor, I think quite surprisingly, because there is a clear distinction between the applicable law and the place of arbitration and the rationale underlying the two choices. Third, convenience. Convenience includes efficiency of court proceedings, language, established contacts with lawyers in the jurisdiction, and of course the location of the parties and the familiarity of the parties, cultural familiarity of the parties with the place of arbitration. Fourth, the general infrastructure, which includes also cost, transport connections, and the existence of hearing facilities. And finally, more specifically, the location of the people involved in the arbitration. And I think this is quite remarkable that it's only the last consideration given the importance of and the impact on the costs of the proceedings. So to summarize, legal considerations seem to prevail over practical and cultural ones. So what seems to matter is really the overall arbitration-friendly environment at the place of arbitration, as reflected in the law applicable to the process and the general reputation of the courts and of the legal community of the jurisdiction in question. It is well known that there is nowadays fierce competition among jurisdictions to attract international cases. And commentators have observed that this is not only to ripen the immediate economic benefits, of course, of attracting cases, which means of course, the use of facilities, hotels, restaurants, legal services, of course. But there is also a somewhat intangible benefit, which consists in gaining a reputation for being a venue for international arbitration, which has to do with being a place where the rule of law is generally respected. And so people are happy to go and see their disputes resolved there. So the success of a jurisdiction as a place of arbitration is increasingly regarded as an important factor to raise the country's reputation as a place where the rule of law is firmly established. Now, if there is consensus with respect to the minimum requirements for a jurisdiction to compete for a place among the top venues for international arbitration, and this is, of course, as I said, the establishment of an arbitration-friendly legal framework, there is also little doubt that this depends on adopting a progressive arbitration law, and as I said, the signing of the major international arbitration instrument, and also an efficient and impartial judicial system, and more generally, as I said, adherence to the rule of law. So it is quite clear, for example, observing ICC empirical data, that adopting a new arbitration law, an arbitration-friendly law, certainly attracts more cases to a certain jurisdictions. Now, in theory, any law which recognizes the preeminence of party autonomy and limits unwarranted interference by courts would qualify for this purpose. But these objectives can be achieved in different ways if we look at the legislation. For example, 4 of the 5 top places of arbitration worldwide have adopted, and this is Switzerland, the UK, France, and New York, have adopted arbitration laws which are not modeled on the ancestral model law. In practice, however, it seems that the model law has become the benchmark for any jurisdiction hoping to attract more international arbitrations, as can be seen from the fact that I would say most, if not all, recent legal reforms in several jurisdictions have been driven by the intention to bring the legislation more in line with the model law. So this shows that enactment of the model law is unquestionably an asset for a country to become a serious player in this market of the place of arbitration, although, of course, per se it cannot guarantee success, and there may be other ways how this goal can be achieved. It is also important to see to what extent the support of local authorities can be regarded as a key factor. In a debate of a few years ago, Theresa Cheng, who's currently the president of the Hong Kong International Arbitration Center, argued that Hong Kong's evolution in importance as a place of arbitration did not come from what she called an artificial intervention of the government, but rather from what she called natural selection. Governmental initiatives, of course, may serve to build a seat in the short term, but long-term survival hinges, as she said, upon the intimate ability and intimate understanding of people in a particular jurisdiction. So this could in part, this argument could in part explain the conservatism I was referring to a few minutes ago. But this position, of course, is not universally shared. At the same debate, Michael Wang, a well-known practitioner, identified, considering the success of Singapore as a place of arbitration, identified the main reason for this success in organized initiatives which managed to grow the country's reputation and establish what he called Singapore as a brand. And among these initiatives, he listed up-to-date arbitration legislation and institutional arbitration rules, of course, the appointment of dedicated arbitration judges, a neutral and corruption-free legal system. Others also stressed, and I tend to agree with this position, that in order to achieve this goal, governmental initiatives need to be supported by the active involvement and support of the local arbitration community. Now, changing for a moment the focus between old and new venues of arbitration to the competition between the top destinations, so we are now inquiring not how to enter the rank of the most popular places of arbitration, but rather how to improve the ranking among the first 5, which may also tell us whether we'll see a change in the foreseeable future. I think, of course, that the fact that, as I say, this is an increasingly competitive market means that original market leaders now have to raise to the challenge of new centers, and also that the more sophisticated the users, which means the parties, their counsel, the more selective they will be in the choice of the place of arbitration. And so they will be extremely careful to sometimes details of what makes a certain place of arbitration better than other, generally equally good places. Jan Paulson recently observed that the finality of arbitral awards and the speed and cost of the overall process, including the possible review by local courts, are the essential factors taken into account for the purpose of selecting the top place of arbitration. Now, I think it may reasonably be expected that all the destinations which aspire to being the ideal places of arbitration meet these requirements. They all have up-to-date arbitration laws and arbitration-friendly judicial systems, which doesn't interfere with the arbitral process. So whenever all these essential requirements are met, then we need probably something else. And this is, in my opinion, the active promotion of finality and speed by the local legal system. And I think 2 examples very quickly are relevant in this respect. One is the possibility of obtaining anti-suit injunctions in support of arbitration, and the second is enforcement of emergency arbitrators. I'm referring very briefly to these 2 aspects as examples. The role of the court's power to issue anti-suit injunctions in support of arbitration and the role it has in enhancing the chances of a certain jurisdiction of becoming a top ranking place of arbitration is well illustrated by Lord Hoffman's opinion in the well-known 2007 West Anchors case. He described the use of anti-suit injunctions to enforce an arbitration agreement as an effective manner in which courts can proactively assist the arbitral process. So if you can bear with me for a minute, I will quote from his opinion, and he put it clearly in terms of competition. He said, courts are there to serve the business community rather than the other way around. No one is obliged to choose London. The existence of the jurisdiction to restrain proceedings in breach of an arbitration agreement clearly does not deter parties to commercial agreements. On the contrary, it may be regarded as one of the advantages which the chosen seat of arbitration has to offer. It should be noted that the European community is engaged not only with regulating commerce between member states, but also in competing with the rest of the world. If the member states of the European community are unable to offer a seat of arbitration capable of making orders restraining parties from acting in breach of the arbitration agreement, there is no shortage of other states which will. There seems to be no doctrinal necessity or practical advantage which requires the European community handicap itself by denying its court the right to exercise the same jurisdiction. Very clear, I think. Second point I was mentioning, obtaining a decision on urgent interim relief from an emergency arbitrator prior to the constitution of the arbitral tribunal is now possible under the most popular international arbitration institution rules, including the ICC, the LCIA, SIAC, and I understand the Finnish Arbitration Institute and the Stockholm Institute. However, the enforceability of these orders may still prove problematic, particularly due to the uncertain characterization of these orders as awards or of the entire process as arbitration. Now, to resolve the problem, a number of jurisdictions, again in Asia, including Singapore, Hong Kong, have adopted specific legislation to allow the enforcement of orders made by emergency arbitrators, regardless of the nature or the characterization of these decisions as orders or awards. Now, given the growing importance of effective, urgent relief at the early stages of the dispute, sometimes before the constitution of the tribunal, I think this enforcement regime is likely to play an important role in the choice of the place of arbitration in the future. Now, I know I'm running out of time, so I will come to my conclusions, but before doing so, a few remarks on Finland as a place of arbitration, without, of course, pretending to express any firm view about a situation and a jurisdiction I'm, of course, not very familiar with, and I'm not qualified, of course, to express any view on. Well, first of all, a few numbers, and I must say these are not very good. Only 18 ICC cases were settled in Finland over the last 10 years, less than 2 on average. Over the same 10-year period, more than 100 Finnish parties were involved in ICC cases. This means that Finland, in one of those cases, where there are no comparable trends between the choice of international arbitration, particularly ICC arbitration by Finnish parties, and the choice of the country as a place for arbitration. And I'm quite familiar with this phenomenon because, again, my country, Italy, follows similar trends. Italy was third last year in terms of number of parties, and only 16th in terms of choice of the place of arbitration. And perhaps there are other similarities between the two countries to which I will come in a minute. Finland is a signatory to the New York Convention. It has, in addition to arbitral institutions operating in the country, an excellent local institution in the Finland Arbitration Institute, whose rules were amended quite recently to follow best practices and standards. Courts have, I understand, and I know from the few precedents I am familiar with, a pretty favorable attitude to the arbitral process. Even more importantly, I would say, we are in a country, most of you have the chance of living in a country which is at the top of the ranking in terms of respect of the rule of law and corruption freedom. And here, I'm afraid, the comparison with my country stops. It's almost scary how corruption-free this country is. So most boxes are ticked to have a good place of arbitration. So what is missing? There may be, of course, general considerations which go beyond the quality of the country's arbitration system, strictly speaking, and which prevent the jurisdiction from imposing itself as an important place for international arbitration. For example, the bargaining power that Finnish parties may have in this respect. I understand, however, I also understand that Finland has legislation which, though not directly based on the ancestral model law, was inspired by it when it was drafted in 1992. As I said, I, of course, hesitate in pointing to specific aspects of the law, let alone to indicate if and how the law should be amended. However, I think I can mention a few points which just as takeaways for you to consider. First, the law is now, I understand, almost 25-year-old, and I think this is not in line with trends in other countries where arbitration laws have been updated at shorter intervals, especially in recent times. Arbitral practice evolves, and it is difficult to keep pace with it without reforms. Second, and to refer to a more specific aspect, I am quite familiar with interim measures. I understand the law in Finland is silent about the power of arbitrators to order interim relief, and this is generally interpreted not as preventing arbitrators from making orders which would be binding on the parties, if the parties have so agreed, for example, by reference to arbitration rules, but that orders, interim orders, urgent measures adopted by arbitrators would not be enforceable. And here, again, the comparison with my own country comes quite natural because, as you may know, the Italian Code of Civil Procedure contains a specific provision which is quite unique in the international panorama, which expressly prevents arbitrators from ordering interim measures. And this is also in Italy generally interpreted not as making any order or any contrary agreement of the parties as null and void, but as making the order made by the arbitrators unenforceable. And this is traditionally mentioned as one of the most important reasons for parties to stay away from Italy, especially non-Italian parties, to stay away from Italy as a place of arbitration. So correct me if I'm wrong, and of course I'm here to learn in this respect, but I understand that the practical effect would not be much dissimilar in Finland. This may be a matter not particularly relevant, not relevant in all arbitrations, but as I said, first of all, the importance of interim relief in international arbitration is growing, and also what I described as the venue market is increasingly competitive. So a change in the law in this respect, even if considered as purely cosmetic, if I may have a positive impact on the perception of the jurisdiction as being more arbitration friendly. Very briefly, my conclusions before leaving you to the drinks. Competition among arbitration seats is increasingly harsh. This is a matter of fact. The diversification of the international venue market reflects similar trends registered with respect to other parameters, such as the nationality of the parties. But the choice of the place of arbitration by parties, institutions, and arbitrators seems to be made on the basis of criteria different from the nationality of those involved in the process. There are legal and practical considerations which suggest the choice of jurisdictions which have gained a reputation as reliable and arbitration-friendly venues. As far as the legislation is concerned, unless the jurisdiction is historically or traditionally or for other reasons considered as a natural option for parties involved in international contracts, as is the case of France, the UK, Switzerland, or to mention a neighbor, Sweden, it is, I think, undeniable that the ancestral model law is the benchmark and that any departure from it may be seen with a certain degree of suspicion by parties, especially foreign parties. It is possible to brand a jurisdiction and to enhance its reputation as an arbitration center, but I think there are also limits to what these efforts can achieve. And these limits seem to depend on the perceived neutrality and impartiality of the legal system at the seat of arbitration, but even more on the active support of the local arbitration community. And I think this is the challenge, but also the encouragement that I can leave to the Finnish arbitration community after this excellent day in Helsinki, and especially after this impressive conference. I think I can say I'm more than optimistic about the future of international arbitration in this country, but success in establishing Finland as an important place for international arbitration requires both adopting the right measures, in particular legislative measures, and enduring support by the local community. This is by no means a sprint. This is definitely a marathon to which the Finnish community, I think, must be prepared over the next few years. And with this, I thank you very much.
So, dear seminar attendees, we are running a bit late, so I will be very brief and say just a few words on behalf of the Finland Arbitration Institute, or FAI, like we call it. First of all, let me note that I'm delighted to see that there are so many people here. I'm positively surprised. I think we are close to 300 registered participants, which to me shows that our traditional Helsinki International Arbitration Day has clearly become one of the foremost annual arbitration conferences, not only in Scandinavia, but in the Northern Europe more generally. And we will reconvene here in Helsinki again next year. I believe the exact date will be announced shortly. I also wish to thank all of our speakers, panelists and moderators. for putting together a highly interesting seminar program and lively discussions. I think we owe the success of today's event to your hard work and efforts, so thank you everybody. Now, as every conference should end on a positive note, I would like to conclude by saying that a lot has happened in the Finnish arbitration scene since I started at the helm of the FAI board a couple of years, or 3 years ago. First of all, we have adopted revised and state-of-the-art arbitration rules, which have been in force now for 3 years. And I think it's fair to say that the new rules have worked well in practice, since they have received a lot of positive feedback from both Finnish and international users. Second, the fact that we now have an international board with a number of distinguished international arbitration specialists as members has obviously been a major change and a positive one. I think it's fair to say that it has greatly benefited our institute in finding optimal arbitrators in complex cross-border disputes and also in administering our cases according to the very best international standards. And last, I would mention that we have also sought to actively raise the FAI's international profile, for instance, by arranging joint arbitration seminars with other leading arbitration institutes, such as our beloved neighbor, SEC. We have also launched just recently an electronic newsletter, and we have also created an annual Finnish Arbitration Academy, which is a half-year study program consisting of various models intended to educate the participants in becoming skillful and efficient arbitrators and also counsel in arbitration proceedings. So against this backdrop, I'm happy to note that Finland seems to be gradually transforming from something that used to be a backwater of international arbitration into a much better known and more reliable venue for international and cross-border dispute resolution. And I believe that our brand new mediation rules will further contribute to this development, coupled with an increasing interest in mediation among Finnish and international businesses. But there is only so much that any institute can do. I personally think that in order to further increase its international appeal and credibility, Finland should consider revising its arbitration law too. As Andrea mentioned, our current Arbitration Act dates back to the beginning of the 90s. It is a bit old-fashioned. We are not a unilateral model law country, and I think there is a clear need to update the law and bring it fully consistent with the very best international norms and practices. And personally, I believe that the time is ripe for Finland to adopt the unilateral model law on arbitration, lock, stock and barrel. And I know there are many others in Finland and abroad who share the same view. And in fact, the Finland Chamber of Commerce has already started preliminary and informal discussions with the Finnish Ministry of Justice on this specific topic. So hopefully we will be able to report on some progress on this front as well in the not too distant future. Now, time is running and I'm sure that you are eager to continue discussions over the cocktails, so let me add just one more thing. We have a very special guest of honor present here today in the first row, namely the United States Ambassador to Finland, Mr. Charles C. Adams. As some of you may know, before his career as a diplomat, Mr. Adams built a reputation as one of the world's preeminent international arbitration practitioners. Among other things, he was the managing partner of the Geneva office of Aiken Gump, Strauss, Hauer and Feld, where he also led the firm's international arbitration practice, with a focus on high-value disputes. And it gives me great pleasure to inform you that Mr. Adams has kindly agreed to deliver a speech in connection with our dinner, which will commence 7:30 sharp. And I'm sure that all of us look very much forward to hearing what Mr. Adams has to say, considering your multicultural background and vast experience in international arbitration. So with these concluding remarks, I hereby close the official part of the conference. I thank you all for your attention. I wish you a great evening and an enjoyable stay here in Helsinki. Thank you.